Good afternoon, everyone. Good afternoon, everyone on both sides of the Atlantic. We are here today for an international webinar on a fascinating work produced by two authors on issues that affect all of us across our countries. So welcome, everyone, to this webinar today, who is connecting from the US, organized by the American Constitution Society, together with the European Law Institute of Fundamental Rights Group. So this work today that we're going to be discussing is a work that I think most of us, if not all of us, are concerned as citizens and citizens in a democracy. For everyone here today, just a quick reminder that if you want to participate, you can send questions in the question and answer tab that you see at the bottom of your screen, not on the chat system. So thank you so much, Russ Feingold, today, one of the co-authors of this fascinating book, The Constitution in Jeopardy, a book that has been written together with Peter Prindiville, a book that is available for purchase, and a book that was published last year and that was already, in the short time since it was published, nominated and was finalist for the American Bar Association Silver Gavel Awards, which recognize outstanding work that fosters the public understanding of law and legal system. It is very important to contribute from the work of lawyers needs to not just remain in the legal domains where it's produced, but it is very important that it goes outside and facilitates discussion and generates discussion. And it seems to me that this is what this book manages to do very well. Just very briefly, the book covers the history of Article 5, which is what the book is discussing. Article 5, for our European audience, is the provision in the American Constitution that establishes how constitutional amendments and changes to the Constitution need to be produced. And the book provides a very interesting history of where it comes from, the value of change in constitutional systems, and the role of the people, the subject of those changes, as well as the risks inherent in a system and the difficulties that so far have taken place. But I don't want to take more time than that, because we have with us Russ Feingold, one of the authors, a former U.S. senator, a very extensive background and history in the work of the law. Currently, a professor at university, where he teaches precisely on this subject. That has had already, and certainly the president of the American Constitution Society. So, Russ, let me pass the word to you, or give you the floor, so that you can perhaps tell us a bit about your work, what the book is about, what are the main issues that you think are the vital points that the book seeks to provide, how the concerns that it raises relate to the U.S. international relations, and what kind of trends we see towards authoritarianism, and how the book tries to address them.
Thank you so much, Maria Teresa and Judge Zalar. We have greatly enjoyed strengthening and intensifying the relationship between the American Constitution Society and the European Law Institute. We had the pleasure of attending the annual conference in Vienna a few months ago, and just a few days ago, Judge Zalar and several of us had a very interesting program on the death penalty in the United States and the implications that has for the issues regarding the death penalty generally, and in particular the effect it has on sort of the United States reputation in terms of human rights and those issues. So we greatly appreciate that, and I appreciate your interest in this subject. I mean, this subject of Article 5 of the U.S. Constitution is obscure to most Americans, let alone to for most people in Europe and around the world. But just because something is obscure doesn't mean it's not important and not dangerous. Because in this case, it has enormous implications. And that's why I and my student decided to write a book after I taught a seminar at Stanford University on Article 5. So, what is Article 5? Well, it's part of our original Constitution. There's some debate about what was the first real written constitution, either Poland or the United States, but clearly the American Constitution, ratified in 1789, was one of the first. And it is pretty clear that it's the first one to create a formal mechanism for amending it, for actually altering it. And the reason that we researched and found out that people felt this had to be done is they feared that if there was complete pressure for change and there was no outlet for change, that it would lead to violence again. And so they called this bloodless revolution. And just to quickly read Article 5, it gives the two ways that the Constitution can be amended. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. And then it has to be ratified, whether it's by congressional proposal or by the states, by 3/4 of the states. So those are the two ways. But the interesting thing is, in terms of our history, is the second mechanism has never been actually employed. It has never occurred that 2/3 of the states have applied or petitioned to Congress, because it's pretty clear from the language that Congress doesn't get to take up that idea of having a convention and decide if it's a good idea. It's mandatory. It's really ministerial. The Congress has to call the convention. So we only have 27 amendments to the U.S. Constitution in our entire history. All of them are from the mechanism of the two houses of Congress voting 2/3 in each house and then going to the states. Well, 10 of those were the Bill of Rights, which occurred immediately, basically to make sure that the Constitution would be, which had just been ratified, would hold. So there's only been 17 amendments. And that's why my co-author and I the book is called The Constitution in Jeopardy. We think there are two jeopardies. Jeopardy number one is the possibility that a certain far-right movement in the United States is in the process of very seriously trying to organize and cause there to be a constitutional convention called that would be, in my view, and the view of many, a very dangerous rewriting of the Constitution. The second jeopardy, though, is that most political scientists agree that even though it seemed like a good idea to put in this Article 5 to do amendments, it's the hardest Constitution in the world to amend. It is so hard that we've only had 17, and the last one was in 1992. And so, you don't just do amendments for the sake of amendments, but there are things that should be updated. This is an 18th century document that needs some improvement. And of course, other mechanisms in other countries are different. Of course, the British system with a Parliament's primary role, and you don't have a system where things are declared unconstitutional in this way. So this is the mechanism. And the interesting thing is that there were a couple relatively minor amendments right after the Bill of Rights. Essentially for 100 years, there were almost no amendments to the Constitution during the 19th century, except for, of course, the very important Reconstruction amendments after the Civil War, the amendments that had to do with freeing slaves, guaranteeing the right to vote, and the like. But there were no others, to the point that at the end of the 19th century, political scientists were writing that it looks like the Constitution is done, that will never be amended. And in fact, one famous political scientist wrote a book saying, almost like it's a sacred document that can't be touched, like it was handed down from on high. And he said that it would never be amended. Well, that political scientist, was Woodrow Wilson, who later became a very famous American president and who was president when a whole number of amendments occurred. So finally, there was a spate of constitutional amendments in what we call the Progressive Era, which was a response to what was known as the Gilded Age. The oil companies and others were basically controlling the economy. And people started to say, wait a minute, we want amendments to have senators elected directly, not by the legislatures. We want women to have the right to vote. We want to be able to have a national income tax. And of course, the famous and but more infamous amendment during this period was the 18th Amendment, prohibition, that did not go so well. That one didn't last. But the point is, there was this spate of constitutional amendments. But other than that period, there have been very few. So, what's the concern? People might say, well, why not have a convention? Why not just have that instead? Because it's so hard to get things through Congress, especially given the tremendous polarization that we have right now in our political system. Well, the problem is, as you may have noticed when I read the actual article, there are simply no rules and no guidance in the Constitution as to how this convention should be done. Can it be limited to one topic, or can it be all topics? Who are the delegates? Who chooses the delegates? How will the voting be done? Will it be done by the delegates as they're all there, or will it be done by state? So each state gets one vote. So Wyoming gets one vote and California gets one vote. The groups that are pushing for this constitutional convention, that have been working very hard to get these petitions to Congress, started in about 2010 after Obama was elected, sort of in a reaction to President Obama, saying he's a socialist, he wasn't born in the United States, but then they also started saying we need to basically protect the Constitution by having a constitutional convention. And so the Tea Party advocates and others started practicing. And they've had mock conventions where they bring people together in Virginia and they bring in very, very conservative legislators from usually malapportioned or gerrymandered states. And they come in and they are serious about it. If you read no other chapter of our book, I would urge you to get a flavor of this. It brings us up to the present. Chapter entitled, What Trump and the Tea Party Couldn't Do, the Modern Conservative Push and the Mirage of a Limited Constitutional Convention. And one of the former United States senators, a very conservative one, describes the possibility of having this convention in this way. Rick Santorum. He says, we're planning on putting resources, people in place to get us to where the safety's off and we have a live weapon in our hands. This is not the language that Franklin and Madison and others they did not compare the Constitution to a grenade. And this is exactly what they are saying. You might say, well, what are you worried about? Well, we know what they're going to try to do because they have voted at these mock conventions. They had one just a few weeks ago in Virginia for the following. They voted for an amendment that would so constrain the power of Congress to act in critical areas of public policy that Congress would not have been able to act on the COVID-19 issue across the country. They would severely limit the power of our administrative agencies. So, for example, the Environmental Protection Agency would be essentially prevented from acting on climate change or clean water. They would overturn our constitutional amendment that guaranteed our ability to have a progressive income tax and eliminate the income tax nationally, which would be devastating to our military as well as to every other program. And the one that's the most jarring, that shows you that they're trying to go back to the Articles of Confederation, which weren't working, as you may recall from American history. You won the revolution, but we had this loose confederation of states that had no power to come together and do anything to provide for the national defense or deal with trade. They're trying to take us back to that. And the way they would do it is they would allow 30 state legislatures of the 50, not the people of the state whole, not the governor, but just 30 state legislators to vote on a majority vote to overturn any act of Congress or any administrative law. So essentially nullifying the power of the federal government. And that's what they voted for in 2016. A few weeks ago, they voted to make it just a majority of states, so 26 states. So the way they do this, though, is they have it, as I suggested, they don't vote based on population of the states. The delegates aren't set that way. Each state gets one vote. So what you have is a further and maybe even more dangerous example of the misrepresentation we have in our system of government. 2 senators for each state, regardless of the size of the state. The filibuster, which is on top of that, favors particularly the very conservative areas of the country. And of course, our electoral college. which allows presidents to be elected, as happened twice in recent decades, not by the majority of the people of the United States, but by a malapportioned system. And so this would add yet actually a rewriting of the Constitution, basically based on what might be described as an effort to maintain white minority rule in the United States as our country becomes much more diverse. So this is the danger, and they are actively arguing not only that they can get these petitions, but they're ready to say that they already have enough. They're the new Speaker of the House. You may have, some of you, I know this is not what people spend all day on in Europe looking at what's going on in the United States, but I know you heard about the insanity in the House of Representatives of not being able to elect a speaker. Well, they finally elected a speaker. And the speaker is one of the leading advocates for calling this constitutional convention. And he is of a group of people who say there's already enough petitions. Sometimes they even count petitions that were written before the Civil War about slavery as one of the 34 petitions they need. So they could pull an end run. And as you may have noticed, there's nothing in our Constitution. The president has no role in this whatsoever. And it appears that the Supreme Court would have no jurisdiction over it. So it would be purely Congress calling the election. And of course, this only happens if a certain party, we're a nonpartisan group, a certain party wins both the House and the Senate, they would pass a resolution to call a convention. So that's sort of what we're concerned about. Why we that jeopardy. I could talk more later about the jeopardy of not being able to change the Constitution at times where it needs to be changed. But I think we have a real serious problem here that people are not really aware of. And it is sort of the latest fantasy of the right in the United States, but it's beginning to look like more than a fantasy. It's becoming sort of a real movement that people need to know about both here and abroad. So I'll leave it at that for the moment.
Thank you so much, Ross. You have taken us through the book, through its chapters, the proposal that it makes, the setting up the problem in a way that I think is not only very clear, but makes it also very relevant for a European audience as well. The issues that you raise, some of our democracies in Europe are also dealing with. I think generally the trend towards authoritarianism that you have described is a concern for us all, democratic societies at the moment. And I will pass the floor to my co-chair in the European Law Institute Fundamental Rights Group, Judge Bastian Zeller, to raise an issue or raise a question in relation to the issues that your book addresses that are quite relevant or brings or mirrors in terms of our European context. Thank you.
Thank you, Maria Teresa, and thank you, Russ, for very clear presentation of your book and also of the actual situation in the United States. In my observations, I will perhaps focus on the last part of the book, on a chapter called A Way Forward. Of course, I can only agree with the proposals of both authors for a new constitutional politics, since I'm really not familiar at all with the situation in the United States. But I will nevertheless try to be provocative in my first in this observation and one question I would like to have. Namely, while reading your book, Russ, I tried to find some parallels with the situation, as mentioned by Maria Teresa, in some member states of the European Union. My guess is that what is common to the United States and some members of the European Union is a crisis, of course, of democracy, if we define democracy as a system which is based on the rule of law, free elections, judicial independence, checks and balances, effective respect and protection of human rights, and certainly not just human rights of disadvantaged and marginalized individuals. My next guess is that in the United States, in Europe, we have perhaps the same source of the democratic problems. And this is democracy itself in the form of populist, illiberal democracy, many times accompanied by extreme polarization in the society. And populist democracy and polarization by no means is limited in Europe to the Central and East European countries. But I see a fundamental difference between the situation in the United States and the European states, which are members of the European Union, in terms of eventual interventions into our constitutional charters and values, either in positive or in negative way. In the European Union, harmful political interventions in constitutional values are limited by the common values, legal principles, binding rules, and standards that are part of the supranational European Union law. European Union law is a supreme law which national law of the member states of the European Union must not breach. And the Court of Justice of the European Union in Luxembourg, with its 27 judges and 11 advocates general, is a supreme authority in some limited sense, also very effective guardian of common European rules and principles. There are concrete sanctions in place for not respecting common constitutional values in Europe. For example, in October 2021, the Court of Justice of the European Union has fined Poland 1 million euros per day for ignoring the ruling of the Court of Justice of the European Union on judicial reform in Poland. The court in Luxembourg said that this was necessary in order to avoid serious and reparable harm to the legal order of the European Union and to the values on which that union is founded, in particular that of the rule of law. So a populist political party which places national law above the European law can lose elections for that reasons. And apart from EU law, national politicians must also observe the case law of the European Court of Human Rights, situated in Strasbourg, which has 47 judges, 47, who again give authoritative interpretation of the European Convention on Human Rights. And the Strasbourg Court, in more than 100 judgments, referred to the European Convention on Human Rights as being the European public order for those 47 European states. And this includes states which are not members of the European Union. So when we speak about the concept of sovereign states in Europe, or the concept of liberal or illiberal democracy in Europe, we have to take this into account. And an American scholar, former president of the International Sociological Association, Emanuel Wallerstein, explained this well 22 years ago in his book, The End of the World as We Know It. I'm coming now to my question. So as an outside observer, I see the situation in the United States in the aforementioned respect quite different, perhaps more vulnerable to harmful interventions into the constitution, meaning that the quality of political elite or of the political representatives in the United States is much more crucial factor which determines the success of any attempt to change the constitution, even more so to change the state of democracy. In other words, the process of changing the constitution in the United States is much more open, much more political than a legal issue. It is more free-handed than this is the case in Europe. It is also more sensitive for eventual worsening of the situation, as this is the case in Europe, perhaps. But on the other hand, the influences and effects of globalizations are coming from the United States towards the Europe and not vice versa. So this would be my first observation in light of your book, and I would like to hear what do you think about these observation of mine?
Very interesting and thoughtful, and I'll do the best I can to make the comparison. I mean, the first thing I would say is, we know that in some of your member states that a perfectly constitutional mechanism was used to change constitutions to illiberal constitutions. It was legal under the system. And also I would note that even though there might be populist movements that moving to the right in some of the European countries, that those are based on popular vote, that they may be troubling, but they are actually based on a democratic mechanism, such as how the person who's the prime minister of Italy now, it's a seemingly a legitimate election. So what's different about our system, and of course you've made the other point, is you actually have a mechanism so that the member states have to adhere to the general law and principles of the European Union. We have none of that in the context of a possible constitutional convention. And so, as you well know, our Supreme Court does have the power to intervene and say, this state law is unconstitutional, it violates human rights, and they've done that. But they also, of course, make rulings such as many of us are very concerned about, the anti-abortion ruling, the Dobbs ruling. And what's going on now is a reaction to that. Last night, the people of Ohio, a very conservative state, voted overwhelmingly to protect a woman's right to choose. And so what's happening is the political system is responding and sending a message that even in very conservative states, people don't like this ruling. What that can lead to eventually, well, it may take a long time, is the composition of the Supreme Court changes and they overturn that decision. It would be based on democratic political competition. What this constitutional convention, though, is the opposite. The Supreme Court apparently has no ability to apply any human rights rules or any other rules to what they come up with. They can do anything. Article 5 is the ultimate I was taught this in England, the positivist document, which is it is completely neutral in terms of content. It can do anything. In fact, there is still a valid constitutional amendment out there. It's not valid from the point of view that it's been ratified, but it's a constitutional amendment that Abraham Lincoln even considered supporting, which would have eliminated slavery in most states, but preserved it in some states forever, making it unamendable. That amendment is still out there if people were crazy enough to ratify it, because this amendment process is independent of the judicial system, of the Supreme Court, and of Congress itself, because once it's passed, it is the fundamental law. So what this is even though you have tremendous challenges there with some of these movements, this is a way to empower a far-right populist movement in a way that doesn't even reflect the majority view in the United States. It reflects a very unfair, malapportioned mechanism whereby it is not based on real representation. It's based on archaic aspects of our Constitution. And that's why, as you suggest, later in the book, we talk about ways in which we could change that. But we're in much greater danger than you are in this regard, because you have a mechanism, as you well outlined, that can prevent countries from going in this direction, such as Poland.
Thank you so much, Russ, for your engaging with this European side of the story. There's more of that. I think your book obviously discusses Article 5 of the Constitution and the suggestion that maybe there may be a need to reform Article 5 so that the actual reform of the Constitution can be done in a safe way. We are seeing some of that in our countries, and I think your book goes to something much more fundamental, which is how is this to be done, and to make democracy truly democratic. while addressing the issues and the risks that arise from the times that we're living in, the times of populism, and the times where illiberal democracies, as Judge Saller was talking about, can take us in different directions. We are seeing some of that. You've mentioned the threat from the right. We are seeing a threat from the extreme left sometimes as well. We are currently engaged in that in Spain. In a process where the difficulties in reforming the constitution are resulting in movements or attempts to circumvent it. And one of the first steps is precisely to undermine the independence of the judiciary. The European Commission has already warned Spain that it needs to change the way it elects judges. Certainly, judges to the governing body of the judges, and judges to the highest instances of the judicial system. But this has not happened. The European Commission publishes its report on the rule of law every year, and there are constant recalls for judicial independence. So what we have seen in Europe is that the threats and the risks of reforming constitutions are so high that we have taken the pragmatic approach to not touch them, just in case, not to open a Pandora box that you actually refer to in your book at some point. And precisely because the independence of the judiciary may have already been compromised, we cannot count on a court, on a constitutional court or a Supreme Court that might actually have the power to return the process back where it belongs. In the US, you've mentioned the lack of jurisdiction of the Supreme Court. So how do you propose that we address that? On the one hand, I feel very what appeals me most about your book is that call to rethink the way in which popular participation can be made true again. And at the same time, how do you see this with the protection of the division of powers that the rule of law in a truly democratic country also needs?
Well, this is where a fundamental question has to be answered by everybody who cares about this. And it people come down on different sides. There are people on the left in the United States who say, constitutionalism is dead. We should have a majority rule system and just amend, basically like Parliament. You can sort of change the law when you want, although it's not quite that simple. There are those who think that. But I think many of us still believe in this experiment in this country of a written constitution with rights enumerated and protected, and that we shouldn't abandon that. And that means that whatever mechanism is used to amend the Constitution can't be just by majority vote. So there's no stability to the Constitution. But as I pointed out, because it's the hardest Constitution in the world to amend, we need to make some changes. And what we propose in the book is that with regard to amendments that go through Congress, maybe lowering the standard not to 50%, but not necessarily as high as 2/3, maybe 60% of both houses or something to make it a little bit less onerous at a time of polarization to get amendments proposed. Some would suggest we shouldn't have 3/4 of the states having to ratify it. That's not something we really weighed in, but that needs to change. The other thing that we have to change is this Constitutional Convention thing, because there are no rules. I mean, even James Madison said at the time, okay, we put this in here now, but what are the rules? What's a quorum? How do you have how's the voting work? We should amend Article 5 by constitutional mechanism to allow the Congress to create some rules for this. Should it be limited to the topics mentioned in the petitions for the convention? How should the delegates be chosen? And what we believe is that for changes to be enacted in the Constitution, it can't just be ratification or proposals by state legislatures. We think the delegates to these conventions should be elected by the people of the state generally. Otherwise, you're going to end up with these very narrow conservative people making these determinations. So we think that changing the rules. Now, somebody would say, well, how are you going to do that with this polarization? Fair criticism. It would require 2/3 of both houses in order to get this change. But otherwise, What we have is a constitution that is simply ossifying. It is stuck in time. We have an electoral college that makes no sense anymore. And frankly, from my point of view, has brought us two presidents who shouldn't have been president. We don't have a right to vote in our Constitution, and it is greatly under attack. I like to joke around that the founders of this country were very smart people, but they were very weak on climate change. They didn't get it. So there's nothing in our Constitution about the environment, and almost any modern Constitution has that. There's actually a good example going on. It's not a perfect example, but there's a good example of a different type of approach. And that's what's happened in Chile in the last few years. I happened to be with my wife in 2019, just before COVID in Chile, and we saw all the protests going on. And what came out of that was a movement for a new constitution. And it was decided that they would have a constitutional convention. And the people of the country got to vote generally for who the delegates would be. It wasn't picked by the legislature. And what happened was that they rejected all people in current political parties. They elected women, indigenous people, teachers, and others, and they had this constitutional convention. And they made a proposed new constitution, which had to be ratified. It didn't pass. It was 55-45, but now a conservative government's in charge. And they're having a constitutional convention. And that process is a very representative process where the people of the country get to decide as a whole whether to do this. So we think that having a mechanism where any amendment has to get a majority vote, at least in the majority of the states, and a majority nationally, is a way to do it. Again, without eliminating completely the idea that there should be some kind of supermajority requirement. It's not just what 51% of the people think at any particular time. So those are some of the ideas we put in the last part of the book.
Thank you very much, Ross. I think the challenges of a reform are very high. The opportunities as well. There is a generally shared fear to make constitutions too easily changeable, because history has given us some examples of what can happen. We all know that Hitler was elected, and democratic elections and the constitution could be changed in the system. And a lot of what we see in terms of making constitutions almost unchangeable is a result of that past history where things have gone really, really wrong. But perhaps we should open now the floor for discussion and for questions and answers. If you have questions, please write them, type them on the question and answer box that we have on the bottom of the screen. We have already a question that is asking about what can be done to develop a strategy for affecting or controlling the formation and agenda of a convention if it were to be called. So if it happens, if there is no reform or before a reform happens, what can be done about it?
Well, that's a very tricky question. I want to answer it in two ways. First of all, people can try to persuade the members of the various legislatures, and it is the legislatures that send the petitions. That's the way the Constitution sets it up. Persuade them not to vote for these in the first place, so that they don't get valid 34 petitions. Some states, have passed these petitions over the years on different issues, but it's a strange part of American law. They don't die; they're just out there. And so what some states are saying is, we don't want a constitutional convention run by the far right. So they repealed or rescinded, or the state of Oregon last year rescinded all their previous petitions. So that's a state that these people were counting that is no longer being counted. Now, if the Congress calls a convention, we're going to have a constitutional crisis, because how do you have a strategy about handling the convention when you can't get in the door? In other words, if they're going to just pick, in the vast majority of states, very conservative people, right-wing people, to be the delegates, yes, there would be some delegates from some liberal states, but they would be so far in the minority. How would they be able to win any votes to create? I mean, they're going to have to create the rules. What are the procedures? Because it's never been done. They'll have to convene and then create the rules, because Congress can't do it. So I don't know. So but to be candid with you, there are people, progressives, people I agree with on many issues, who really do want to see a constitutional convention. They think maybe it would turn out well. The governor of California, Governor Newsom, recently proposed a constitutional convention to try to change our gun laws in the United States, which many people think would be a good thing because we have this problem of the way in which the Second Amendment's been interpreted to give a very broad right to bear arms. Sounds good in theory, but what happens if 80% of the delegates are hardcore pro-gun people, which it probably would be? They wouldn't do that what he wants. They would actually make the right to bear arms even more extreme. And how does one stop that? Same thing for campaign finance reform. I was very associated with that issue as a senator. And we have a terrible Supreme Court decision called Citizens United that basically ruined our campaign finance system. So naturally, there are people that want to have a constitutional convention that would consider overturning that decision, which I think would be great. The problem is the delegates who are training to be the delegates and are likely to be the delegates wouldn't even think of doing it. So, in theory, you could try to have a strategy, but I don't know how it would work. I suppose the only thing people could do is to try to somehow appeal to the United States Supreme Court and say, you need to figure out a way to say that you have some jurisdiction here, which would be very, very difficult with any Supreme Court just because it doesn't look like they have jurisdiction. But especially because we have a Supreme Court where there are people that I think would be very sympathetic to this. Some of them would be sympathetic to the idea of this convention anyway. So it's hard to think of what the strategy would be.
Yeah. What political changes? There's another question that asks, what political changes do you think are needed to allow for bipartisan action in order to reform Article 5, considering today's political climate? And I'd like to make a note here for our audience that you have a very high record of bipartisan vote. This is something that I also find quite appealing in our current context. Now, for our European audience, what this means is that, if I remember correctly, you rank a 6 in bipartisan vote at the time. So this means that you have a long record and a history of finding consensus across parties and working for proposals and voting for proposals that gather a consensus and more of a majority that is therefore more representative of the different sensibilities and approaches in what in a liberal democracy should be a pluralistic society. So the question here on what would you do? What do you think is needed in order to move towards bipartisan action in this current and consensus in this current political climate?
The only way to break through this problem of the way our Constitution's set up, and John McCain and I worked for 8 years on a bipartisan basis, and the rule we had was that whenever we added one member from one party as a co-sponsor of our bill, we had to add one from the other, so it never became lopsided, and that worked very well. But what would have to happen here is some members of Congress, and there are people like this on both sides, would have to come together and say, look, we don't know what a constitutional convention should actually do, but we do know that the Article 5 needs to be changed. And if they came together, people like Liz Cheney, who of course was heroic on the whole investigation with Trump, people of that stripe coming together with some Democrats who are willing to do this, to propose a commission, not a commission of congressmen and senators, but a commission of the public, like our 9/11 commission, and to propose a series of sort of neutral changes that would change the mechanism in Article 5 to make it work. Because there are things that conservatives want changed in the Constitution that are not crazy. For example, I don't support this, but they want to have a balanced budget amendment. They want to have a rule that we have to actually balance our national budget like the states do. I opposed that when I was in the Senate for a variety of reasons, but this is the kind of thing that some conservatives might say, well, we should make this a little bit more easy to make this process work so we can get changes like that. Some people want term limits for members of Congress to be in the Constitution. I don't like that idea either, but what you can do is have conservatives think in those terms and maybe come together and say, let's create some fair rules where the delegates would actually be elected by the people in their states. So this can be done. I think certainly not in 2024 with our horrific tension in our political system. But once that's over, depending what happens, I'm hoping that cooler heads begin to prevail in this country, because I have this feeling that people are worn out from the enormous tension and difficulties. And this will be a decisive election for obvious reasons, without me getting into personalities, but I think we all know what we're talking about. I think we're going to see a different mood in 2025. In fact, dramatically different mood, depending on who ends up being president on January 20th, 2025. But I think it's possible in the right context.
That's very good to hear. There is another question that you've talked about before, the way in which in some states there have been rejections. So in conservative states, there have been rejections of difficult issues like the woman's rights to choose. And the question here says, what can be learned in terms of the strategies to approach changes to the federal constitution?
I think what I'm learning from watching these votes on the issues, as opposed to when you have a Democrat versus Republican election, is people actually aren't as conservative and extreme as it might appear. So on the same night that Trump won Missouri by a big margin, they passed a minimum wage bill for workers. On the same night that he won South Dakota, they passed a resolution for campaign finance reform. And now in Kansas, in my state of Wisconsin, a Supreme Court race, in Ohio, in every one of those states, even though every Republican in the state is pro-life and very plays to that audience, it's been rejected. When it's not, do you want this Democrat versus this Republican, but do you want a woman's right to choose? Yes. So the interesting thing about constitutional change, it's not about political parties. It's about issues. And so there is a potential here for these kinds of things to be considered outside of the polarization. I think that's what it's proven, is that people will reassert their human rights when they feel they're being directly countermanded, which is, of course, what's happened since the Dobbs decision. And we have this insane thing now in this country where you have constitutional right to choose in Ohio, but if you go to the next state over, you can't do it at all. What kind of a system of human rights is that? It makes no sense.
Thank you. We have a few minutes left. I would like to ask Bastian if he has any questions or thoughts that he would like to bring to the discussion at this point.
Yes, maybe I'll come back to you mentioned several times that Article 5 is neutral.
Yeah. In terms of, there's nothing in there that is except for one thing which we could talk about. But basically, that's right. It's positivist. It's content neutral.
Yeah, and to follow up my first observation, for example, we have from 2019 so-called principle of non-regression. It was introduced by the Court of Justice of the European Union based on the question that was sent to Luxembourg by Polish judges. So Polish judges actually provoked this principle, which says the following: that the one article from the Treaty of the European Union must be interpreted as precluding national provisions relating to the organization of justice, which are such as to constitute a reduction in the member states concerned in the protection of the value of the rule of law, in particular the guarantees of judicial independence. So this is now the constitutional principle that any reform should not mean a regression of the rule of law. For example, in Slovenia, we are now in the middle of the amendment of the constitution. And the politician at the start of this process wanted to introduce a 3 years probation period for judges, which would be a new system. And we invoke this non-regression principle, and the politicians abandoned this idea. So you see, it works very well. And you mentioned also several times that one option is that people would persuade the politicians not to not to call a convention. My question to you is, what is do you see the role of public intellectuals in the United States as being an important factor in relation to prevention of these threats to the American Constitution?
Judge, I'll start with the second one first. Yes, one of the reasons we wrote the book is that we felt that the public intellectuals in the country and the media and others not only had no awareness of this concern, but they didn't believe that there was a real possibility that this could be organized. And they sort of rest on the idea that, well, whatever would come out of the convention would require 3/4 of the states, and that's going to be too hard to get. Well, 34 states calls it, 38 states ratify. So we question that. And so what we did is we went to a lot of the public intellectuals who are law professors, constitutional law professors, and we engaged them on this. So if you look at our book, we have blurbs from some of the leading constitutional scholars who never thought about this. They admitted that when they read it. They said, this is a big concern. So what has happened is we now have a lot of discussion. The New York Times has covered this heavily. The Guardian has covered it. A lot of law schools. We've had, I was at a conference at Columbia University where this whole question of constitutional change was discussed last February in a very detailed way that we've never seen before. So I do think they play a critical role in getting people aware of it, but also just individuals back in their home states talking to people directly, to members of the legislature is important as well. This non-regression thing is very interesting and very promising because we, as you said, we simply don't have that. There is a principle in some countries that there can be unconstitutional constitutional amendments. I believe that's the case in India. I believe that's the case in Israel. And, in other words, something that is, even though it might not be explicitly prohibited in the Constitution, is so anathema to the whole idea of the document that a court could actually say, you can't do this. Now, that authority is not in Article 5, but it leads to amazing thoughts. I mean, technically, slavery could be reintroduced in the United States. There's nothing in Article 5 that would be prohibiting it. You might say, because it would be a more recent amendment than the 13th, 14th, and 15th Amendment. So it's the most recent law, Judge. And so that would be the law. It would overturn the Reconstruction Amendments. We don't have that sort of protection. And so this would be a very controversial thing. What would be actually protected and what wouldn't? I've seen in other constitutional systems, I did a lot of work in Africa and Congo for the Obama administration. They had so many problems with presidents never leaving when they had, been president for a while, that they actually put in the Constitution a provision you can only serve 2 terms, and it is unamendable. In other words, you can't change the Constitution to provide for more terms. So that's sort of like a non-regression thing. What goes on in some of the other countries, like Rwanda, is they have a constitutional provision that says you get 2 terms, and then the president proposes a constitutional amendment to allow him to keep being president, like Kagame did, and so he's going to be president for life because they can change that under their constitution, even though it is in the Constitution. It can be changed. So I think you're getting at an important point here. Certain immutable principles may need to be given the status of unamendability when it comes particularly to human rights issues, but we do not have that at this point.
We have a couple of minutes, and I'd like to go back to the broader question of the democratic element in the constitutional processes. In Europe, one of the sources of fundamental rights in the European Union's legal order is the constitutional traditions common to the member states. Now, what exactly that means, and what does it mean for a tradition to be common to the member states? It's a matter always in ongoing interpretation. But that reference back to the constitutional text as a source of unwritten law that acts as an element of restriction and limitation on what the positive law can say, it can be very powerful in inner European system. The treaty actually says that in the application of the treaties, the law shall be observed. So that is always a very interesting question. If the treaties are the founding law of the European Union, which other law needs to be observed in the applications of the treaties? And this is what allowed the Court of Justice of the European Union to bring in those general principles as unwritten sources of law. But I do understand you do not have a similar mechanism in the United States, that general principles would not be sources of law. And if they were to be, where would you find them? Because in the European Union context, we can go back then to the constitutions.
A couple of interesting places in the Constitution you might look to. It certainly is not as explicit as that. But under the previous article, Article 4 of the United States Constitution, Section 4, it says the United States shall guarantee to every state in the Union a republican form of government. That means if a particular state starts eliminating judicial independence, if it proposes the idea that a lot of these folks have proposed that the state legislature can ignore who actually wins an election and declare a winner, that these arguably are violations of this constitutional provision. There's also one that has been talked about both by conservatives and liberals, which is sort of open-ended. It's considered to be not particularly full of content, but I think it has potential. Even Joe Biden's talked about it. And that's the Ninth Amendment to the Constitution. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So what it does is suggest a jurisprudence of potentially human rights and others that are still retained by the people, even if they are not explicitly protected in the Constitution. In fact, the Roe v. Wade decision and the decisions before it, Griswold and others, did cite this amendment as one of the amendments that they believed created, in effect, a right to privacy and a woman's right to choose. So there are some handles there, but not as strong as what you've described.
And perhaps to finish up, one more of a question in relation to that democratic origin that you've raised and you've discussed in the book. You make it a point of asking the question, who is the people and how is the people defined? Both Bastian and I work on asylum and migration issues. So there is an element in the population of our countries in terms of displaced populations and sometimes forcibly displaced populations who live among us. In some cases, they pay taxes, they have jobs, they pay taxes, but they're not entitled to vote because they're not citizens. In Europe, we have some of that debate in relation to European citizens ourselves, because the right to freedom of movement from one member state to another allows us to live and work everywhere else. But if you're not a citizen of the country where you live, then you don't have the right to vote for national and parliaments. And therefore, it goes back to that question as who is the people? The question would be, do you think citizenship is or should be the only way for individuals to make that contribution towards the common good, both not only in terms of rights, but also in terms of responsibilities, and also the responsibility to be a good citizen in the sense of participating in government? Especially because of the point you make about the America being born out of a dispute on non-taxation without representation.
Yeah, well, I think it's really important to realize that even though those individuals may not have a right to vote, that we have a great deal of jurisprudence protecting the rights, many of the rights of individuals who are not citizens. They may not be able to vote, but they do have a right to travel from one state to another, and there's a lot of other principles that are very important in that regard. The thing to remember about our Constitution here in the United States, it does not say we the states. It says we the people. And as you suggest, that is not necessarily only those who have a right to vote. Now, it's an interesting question because, as we know, the people that were in that room in Philadelphia, no women, no African Americans, no Native Americans. We the people, one would think, was everybody, even the people that weren't in the room. And that can also include people who are not citizens. It doesn't say we the citizens. It says we the people. So you can start right there to develop a stronger tradition in this regard. And of course, a lot of people are trying to unfairly deny people the right to vote as well, which needs to be dealt with. But yes, there needs to be a greater protection of the rights of these individuals.
Thank you very much. I think we've run our time, so I would only just like to thank everyone for a wonderful discussion. Russ, for presenting your book to us. This is a very important work that affects, that might seem to be concerning only Article 5 of the American Constitution, but the issues that it raises are very relevant for democratic countries across the world, and especially in our European societies as well, and issues that it's worth discussing and engaging with. So thank you very much for your time today. Thank you very much to our audience. And I will just ask Boston if he wants to say something at this point.
No, I would just like to thank again to Russ for this opportunity, and you, Maria Teresa, for chairing this roundtable. Again, it was a great experience for me, especially since I'm a judge, and I had an opportunity to speak a little bit, as a, let's say, public intellectual. Thank you very much.
Well, I thank both of you, and ELI and we at ACS are thrilled to have this relationship with you and want to broaden it, and looking forward to the gathering in Dublin next year. Thank you very much.
Thank you very much, everyone. Thanks a lot.